Hello, everybody. This is Joe Stapleton with Exit Engine and Exio Advisors. We are welcome to another Wednesday webinar. We got a great one today, guys, because we're going to get into something that is a really big value creator, and it often goes so far under the radar. My guest today, you may know from being a guest on our podcast recently, but Brenna Lagarde is an IP expert. She's with a company called, actually a partner in a company called Invinio Law. And she's here to tell us today all about the ways in which we can actually find IP, understand what intellectual property is, and how it's actually going to be able to actually add value to your company, sometimes really just by recognizing you have it. Right, Brenna?
Absolutely. Absolutely.
So this is such a great topic and a huge one because, again, as we've talked about before, people are unfamiliar with what really intellectual property is, right? Most people think about it as some kind of like a patent, right? There's obviously more to it than just patents. There's a lot that goes into it. So today, what we want to do was kind of set the stage, talk a little bit about what intellectual property is, right? Talk about how you can identify the IP that you actually already own. Understand what it is that buyers are looking for when it comes to one day when you go to sell the company, and also what they penalize. And let's try to figure out also about figuring out the pitfalls around IP, and the things that actually potentially can kill deals if you're not prepared for them. So, Brenna, let's just jump right in. Talk to us and give us a kind of background on what intellectual property really is, and how we can spot it inside our own companies.
Absolutely. Absolutely. And thank you for having me.
Sure.
I love this topic. Maybe if it's all right, I'll take a minute to talk about how I sort of arrived at where I'm at in this sort
Absolutely.
of process with my clients. So I'm a lawyer. I'm a patent lawyer, which means I have a science degree and took an extra test. Um, and when I started my career, it was with a pretty traditional patent firm, and so people would come to us with their inventions when they had kind of decided that they needed a patent, and then we would write up what they brought and get a patent on it, and then kind of what they did with it after that was entirely up to them. That wasn't
Right.
something that we involved ourselves in at all. Um, and they were my original partners. They were exceptional patent lawyers. I learned so many formative things from them. But there came a day when a startup client came to us, and they were they've been doing this for long enough for their cap table to be kind of a mess. They were out of money. We've been working with them for a while. We gotten them any number of patents, but they hadn't been able to really move the needle with any of those things that they'd gotten.
Okay.
They weren't really able to defend the market share or kind of point to any of those assets as something that would present a barrier to entry that would convince anyone to fund them.
Right.
And they were out of money. So they actually came to me to tell me pencils up because they couldn't afford me anymore. And I said, all right, well, I've had concerns about this for a while. So let's just go through your portfolio and figure out where you're at. And so I went through their portfolio. I became convinced that they were patenting their sort of incremental improvements, right? But not sort of the underlying invention that made all that improvement possible.
Right.
And it's hard to patent a lot of times kind of an incremental improvement, right? And but it's more fundamental structure, like that was fair game. So
Okay.
so I convinced them to just kind of pivot to this approach. We got that patent. They were able to fund the company. They're still alive and kicking today.
Right.
And that got me really interested in the need to really get involved in what are clients doing with the stuff that we're getting them.
Right.
Like, should we be kind of wading into their business models and figuring out what their competitive advantages are, and kind of figuring out whether we're getting them stuff that's helpful, or whether we're just getting them the stuff that they're asking for and calling it a day.
Right.
And this was uncomfortable. This is 20 years ago, right? So this is a little uncomfortable in the legal profession, right? Like, a lot of the patent lawyers I was working with are like, we're not business people. We have no business in that. But it struck me that like, the clients were only getting half of what they need, if that,
Right.
without more thought about where are you going with this. And so
It takes it away from being, just to interrupt for a second, but just to show, I
yeah.
mean, what's happening here and what happened over the last 20 years for you was that you were even realizing and saying, hey, look, there's IP that you just kind of have, and it's an asset, and people, you kind of are familiar with what you have, and maybe you've actually launched, gotten off the ground by having IP, right? Which seems to be like the common way traditionally that people do it. I invented a thing and I'm having it made and I'm manufacturing it, and the patent process is kind of part of that. And so I've made an invention, I've patented it, that patent's going to last for a certain amount of time, et cetera, et cetera. And it's and that's it. But what you realized in that moment was, wait a second, strategically, right? What are we going to do now with this IP that's actually going to add value to the company overall and become a real asset, right? That we can do something with if we want to. Is that pretty much what happened?
Yeah, I mean, patents are exclusive rights. Like they're the right to stop somebody from doing something. And if it's the right to stop somebody from doing something they have no interest in doing, then
Right.
know,
Yeah, exactly.
Right? My kids have never once eaten all of the kale.
Right. Exactly. So you don't have to put hey guys, you don't have to put a rule in about eating all your kale, right? Exactly.
I need no exclusive rights to guard the kale. It's fine. Even when I had cookies in it, it's generally okay.
But that's a great point. That's a great point, because that's not, people aren't thinking in that way, right? In general.
Yeah. And the thing is, like, big companies have legal departments, right? And they've got innovation, technology, committees, and they've got, a lot of sort of people and infrastructure around trying to figure out, what is a relationship between, the intellectual property that the company's spending like some real money getting and its competitive advantages. But the like small to mid-market companies don't have that. And so if we lawyers aren't doing it, then, they're going to swing and miss because they don't have what they need.
Right.
And so I started thinking really hard about how to be what they need. And, and this was generally in the kind of startup funding sort of growing space. And then I ended up at a law firm that, that had a pretty healthy M&A practice. And so I started getting pulled in, at the time of these, again, like mid-market companies were at exit, right? And it was kind of like, oh, well, you're at exit, let's talk about your intellectual property. But a lot of them hadn't thought of themselves as tech companies. They hadn't given any thought to their IP. And so they're at exit and they're getting questions about like, okay, well, you have this product that you're selling that's profitable. What is to stop anybody from coming in and just doing that? And like the answer, frankly, is nothing,
Yeah. So I mean, that's the first point right there. Let's stand on that real quick and make sure that we're clear. The first thing that you talk about, and we've talked, because we talked about this so many times before, is is the anything in your business potentially is copyable.
Mm-hmm.
Right. So
yeah.
Right off the bat. So right now you've created the greatest thing that you think that you've created in the whole thing, and immediately out of the gate, anybody at any point can take it, make it their own, do whatever they want with it, right off the bat. So and that goes for process, for just about, for lots of things that
everything that you invent. Yeah.
Right.
Yeah. I mean, the world's default rule is all ideas are up for grabs. Copy anything you want, unless it falls into a category of intellectual property and you've managed to protect it in accordance with the rules of whatever the category that is. Right. And so I was entering these deals like, at the diligence phase, and I'm like, well, we can register your trademark, but like your trade secrets are kind of, they've left the barn, it's too late to try to patent anything.
Right.
Like there's only so much I can do, and often it was a disappointing amount, because a lot of times these are very innovative companies.
Right.
They had solved lots and lots and lots of problems, but they'd solved them for the world. Those founders couldn't capture that value in the way that they could have had they tried to get some exclusive rights around them.
And now they're sitting there at the table, right? Like in the 11th hour, trying to figure out, hey, what's the value of our IP? Because the guy's asking, right? Mm-hmm. And it's like, well, wait a second. The guy who's asking is asking this because he's about to buy your company, right? Yeah. And the assets that are coming with that company, he already recognizes as intellectual property that needs to be protected. And it's a major red flag about your company that it's not protected.
Yeah.
Because it begs other questions, right?
It does. It not only means it's fair game for anybody who can figure out or wants to do it, but it also means like, how valuable is it if you didn't care about it? Why should I care about it if you've never cared about it?
Yeah.
Which, is a good question.
Point. Yeah, absolutely. No.
Yeah. Sure. Yeah. And so, from there, I joined Invenio, which is a company that's focused on the third party litigation funding space,
Right.
right? Which in some ways is a great place to be an IP lawyer, and in some ways is a little odd, right? But the thing about it is, so I've spent the last 25 years, getting companies patents and trademarks and trade secrets and things like that, right? And so I'm here at a place where, third party capital is another really important tool that enables me to kind of help them do something with them,
Right.
where it's appropriate, right? And that's so the focus. So my focus now is very much on, you've got this IP, like what are you doing with it besides paying maintenance fees on it? What could
Right.
you be doing on it? I've been
Yeah.
very involved in, in figuring out how to use data and data analysis tools and things like that to, to kind of figure out, where the value is and how do we unlock it.
Right.
Um, and
Yeah.
so, and again, like these resources have always been, I don't want to say easy to find, but they've always been available to, to big companies. But, if you're in that mid-market,
That's the thing.
it's
And by
hard.
the way, yeah, and that by the way, this is why we do all of this, right? Is because these companies down here at the lower end of the middle market, right, or the crossover companies that we work with, right? They actually have no clue. And the
Yeah.
reality is not their fault. It's because they haven't had to face it. They're not sitting there in a giant corporation that already has lawyers, that's been around for 30
Hmm.
years and done, et cetera, et cetera. You have to know what you don't know,
Yeah.
right? And
Yeah.
that's exactly why we're here today. So Brenda, you're now at Invinio, right? And you're doing the work here, of actually helping people establish their IP from the beginning, well in advance, right, of getting to
Yeah.
any kind of exit and that kind of stuff, right? So,
Yep.
talk to us a little bit about what. Again, let's go through. Maybe let's start with what are the
Yep.
categories of IP, and right, just so that we know, so that the first thing we should be looking for is in your own business right now, as Brenda goes through this stuff, start thinking about the things, right, that are, oh my God, that's IP, right?
Yeah.
And start thinking that's the first step, identifying IP.
Identifying your IP. Yeah. Yeah. And so I usually start this conversation with a brief overview of where everything comes from, starting
Sure.
with the 15th century Viennese city state, right? So if you we're going to go back to Vienna, right?
Didn't
So
think you were going to get a history lesson this morning,
I
did you?
know that it's interesting, like it's super interesting and especially relevant now. But anyway,
Yeah.
okay, so for the world over, right? Like copying is free, copy, whatever the hell you want, right? And so in the 15th century city state of Vienna, like their industry was stained glass. They made these beautiful stained
Right.
glasses, glass, these techniques, right? And nobody
Mhm.
wrote anything down in these days. So all this intellectual property, right, like was in the heads of the glass artists. And if those heads left the city state of Vienna or got hit by horse-drawn carriages or something, right, or died of the plague or consumption, like that intellectual property was gone.
Right.
And so the city state of Vienna got worried about this. And so it needed to get people to come in and disclose what they were doing. And so it said, all right, glass artists, really anybody, like anybody who's invented a novel contrivance can come in to the state judicial department and like tell us about it, right? And we'll like write it down. And then
Right.
you get a 10-year monopoly on that thing. And so it was very successful. Like the glass artists and other inventors thought this was a great deal, and so they did it. And the Viennese, government became more, reassured that it wasn't as vulnerable, and the city's competitive advantage and economy weren't as
Right.
vulnerable, and it was awesome. And this idea spread across Europe, right? And it ended up in Britain that did English things to it. Like, first of all, it became kind of a favor to the crown sort of situation, right? So if you're like the royal purveyor of salt to the crown,
Right.
right, your
Right.
salt could be crap, your
You get
prices could be
special
sky high,
favor.
but
Right.
suck it, peasants, I'm buds with the royalty, right?
Right. Right.
And so eventually Parliament's like, no. And so they passed a parliamentary act which limited these sort of monopolies to to new inventions, but there was no examination process to figure out what was new, and royal patronage still helped a lot. And you also had to be able to make the thing that you wanted to patent, right? And so it really only entrenched the dominance of the dominant, right?
Right.
Like it didn't help innovation.
Right. In other words, basically, what it wasn't doing was saying, "Hey, look, here's an idea. I'm going to write this idea down. Here's how you'd go about doing it if you were to do it, and then have that be on record as something, as a patent of some kind."
I
You'd
mean, they
actually
had
have.
that,
Right.
yeah. Like they had a disclosure requirement, but like they didn't. There was nobody, nobody to decide if it was new. So if I'm
Gotcha.
like, hey, I just invented salt, they're like,
You're like,
okay,
sure.
sure.
Right.
Right?
Yeah, yeah. No, but so even identifying what that was, and then to be able to say, is this something that is, again, I think Vienna saw was, hey, we've got an industry that we're trying to protect, right?
Hmm.
And so
Hmm.
let's not allow people, interlopers in here trying to steal the stuff and whatever and undercut us and the whole thing. And you can talk about, in the modern era of, China, and things that they do maybe as a parallel there, right? But the idea you're trying to get across is that the you have to be able to actually produce, right? By the time it got to England, right, you needed to actually make the thing.
I mean, so the point is, right, the monopoly was the carrot, right? Like what
Right.
Vienna wanted people to do was write stuff down
Got it.
someplace where it could be
Be
found,
accessed. Yeah.
right?
Later.
Like
Right.
they
Right.
just
Yeah.
wanted their expertise to be written down and accessible and to build across generations and to be not as vulnerable to the things that happen to humans,
Got it. Right.
right?
Right.
And so like monopoly, here you go. You know,
Yep.
yeah, and so it wasn't about, the glass artists really, like it was about the Viennese industry. And then
Right.
by the time you get to England, like it becomes about the salt purveyor, right? Like
Right.
it's not about the market, it's not about the peasants, it's not about the economy, like it's about like giving you an advantage, right?
Right.
And so then you come over to America around the time of the revolution, right? And so a lot of the founding fathers were a little burned out on this whole monopoly thing because it'd been used against the people, if you will, in England, right? It
Right.
was used
Right.
for the salt purveyors, right? But there were advocates for the sort of Viennese idea that that you can give monopolies to incent disclosure, right? And there was also this idea that that there was a lot of creative genius in ordinary people.
Hmm.
And in the U.S. in those days, right, there was little access to capital. It was a resource-rich but cash-poor economy that had just pissed off its biggest, by far, trading partner,
Right.
right? And so they kind of needed everything they could get, right? And so the idea of the patent system was it's going to enable the genius of ordinary people to lift us up and take us forward. And so the patent system is in the U.S. Constitution.
Hmm.
Like the Patent Act was one of the first things that Congress passed. After the it convened after the Revolutionary War. So like they got on it, like it was a
Right.
priority. And if
Hmm.
you look at like Jefferson's writings at the time, he's like, I don't know about monopolies. It seems like a bad idea. And then he's like, oh yeah, okay, well, like we're seeing like a flowering of technological development here. And
Right.
so some of the aspects of this U.S. system, there's an examination process. So there was somebody to figure out if this was new or not.
Right.
And you didn't have to be able to afford to make it. Like you could just have an idea, right? And so the
Right.
application fees were low. The process was at that point as simple as possible, right? And so the idea was like if you were, some nobody with an idea, like you could get a patent and that incented you to develop your idea and to write it down, all of those
And to
things, right? I
protect
mean,
it so that other people couldn't immediately take it from you who had more resources or had curried favor other places or whatever. Right.
yeah, and you could
Levels the
sell
playing
it,
field.
right? Like there's a third party, there's a secondary market for patent rights. So like you
Right.
couldn't really sell your English patent, right? But you can sell your American patent,
Right.
and so you can sell it to somebody with a factory. You can get paid for your idea, right? Which otherwise was impossible,
Gotcha. And that
right?
spurs innovation, right? So, I
It
mean, the
spurs
idea is
innovation.
it spurs innovation. It's not just
Yeah.
about people writing things down the way it started, right? Now it's also about the reality of now it becomes actual physical property, like actual, like valuable property. Once you have a thing and now you can say, hey, look, even whether I manufacture this thing or not, the idea itself is now worth something, right? And
Hmm.
on the open market, potentially, I can now sell that. And that's
Yeah.
something that makes it an asset really for the first time, right?
Yeah, I've got legal leverage, so I
Right.
can go into business with you, and there's a reason why you can't screw me because I have some
Right.
legal leverage here. With
Yep.
others, I have an idea, which is like open season, right?
Right.
And so the patent system has been attributed to it's been credited with sort of launching the economic powerhouse that became the United States became, right?
Right.
And the other thing is like every country in the world has some flavor of the U.S. patent system, and they're like most of them are like pretty close.
Right.
So it is in a way like up there with democracy as one of our most important cultural exports.
Absolutely. Yeah.
Yeah.
And it's
Yeah.
really
So
it's all part and parcel of the same thing when you think about it, right? I mean, the whole notion of the capitalistic kind of open, the way that the entire revolution was kind of based on this notion of we want to go do it our way, right?
mhm, yeah.
And so this falls right on the heels, which is why it was also so tied to from a priority standpoint, because they knew that the whole idea of getting everybody together to protect ourselves, right? Which
Yeah.
made us a superpower from the beginning, right? Because every individual colony was already potentially at its own country, right?
Mhm.
Getting these things together to protect the borders, to protect the national defense, all that stuff. And this was another way of
Yeah.
basically protecting society and enabling innovation and business to happen within this kind of new paradigm that was created by democracy.
That's right. That's right. And it was, as you point out, right? This is a federal government thing when there aren't that many federal government things.
Right.
And
Yeah.
I mean, democracy is a bet on ordinary people, and the patent system is also a bet on ordinary people, which now doesn't seem that
I like that.
crazy, but in those days it was a thing, right? Like that was a
Sure.
decision. So that's how, like, that's the advent of intellectual property. And
Okay.
so my point, and partially I would tell you that is because it's interesting, but also because um like intellectual property seeks to balance competing interests, right? Like
Right.
there's benefits to, it's supposed to benefit society and the larger economy and inventors and innovation, a bunch of competing interests. And it does this in kind of a variety of different ways. So looking toward, the categories of intellectual property. So again, like all ideas are fair game to copy, do whatever the hell you want, unless the idea falls into a discrete category of intellectual property. And people conflate these categories all the time. They say copyright when they mean trademark, and they say
Right.
patent when they mean, and so I'm going to emphasize these not to be, pedantic, but because they're very different and it's important.
Okay.
So I'll start with trademarks, right? And so a trademark is a word or a phrase, or I mean, it could be a jingle or a mascot, like it's the color blue associated with Tiffany's, things like, it can be kind of anything, right? That a company is using to designate source of its product or service. Yeah, like exit engine, which it doesn't look like you've registered. Have you ever? Anyway, we can talk about that later.
We'll talk about it later.
Okay, yeah. So yeah, a source identifier, right? And so trademarks are primarily, they're supposed to, they benefit like the trademark owner,
Right.
because they enable you to sort of identify your goods and services to your customers, and they benefit your customers who can kind of choose who they're buying stuff from, because they use these source identifiers to tell. Right. So they've got those sort of the kind of public, consumer protection and rights holder protection kind of, dual agenda.
Right. But
Yeah.
that means in practice, okay, just again to take this down to a practical level, right? The idea is just very simply is that when I have a trademark, okay, what that is essentially doing is saying, so for instance, the reason that exit engine is trademarked, right, is to be able to not allow other people to use it in the
Mm-hmm.
same way, and particularly to use it against us. So
Mm-hmm.
in other words, the protection is, okay, this is a brand that is owned by a company that does a certain thing, and right, and of course it's only trademarked within that certain purpose. I can't trademark the word exit,
Right.
but I
Right.
can trademark the lockup of exit engine together as an
Yep.
example, right? And so
Yep.
the idea is that prevents other people from taking my brand, using it adversely, trying to use it to get money for themselves without me getting paid, right? That kind of
Yeah.
stuff.
Yeah, that's exactly right. And so you've also kind of, you've alluded to distinctiveness requirement,
Right.
right? So in order for, so trademark law doesn't want to lock away words that everybody needs to describe what they're doing, right? So you can't get a trademark, you can't get exclusive rights to exit to talk about, exit, because that's a established business concept, right? Exiting.
Right.
And so if you could lock up exit, then your competitors would be denied the use of a word that they really need to be able to use, right? And so the way that the trademark law kind of figures out how to balance those things is by looking at the distinctiveness of a purported trademark, right? So Apple is kind of the quintessential example, right? So like Apple used to describe apples is a generic term and nobody gets to own it, right? But Apple used to describe computers is what we call fanciful, right? And that's distinctive. No other computer maker needs to say Apple unless they're describing the Apple company, which is something, right? So you can register Apple. And so this feels, so the way, so I guess, from a company perspective, like first of all, trademarks arise through use in commerce through the common law. So you don't have to register them, but you really, 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 really should. You should register. There's a whole bundle of benefits that you get with registration that you need. And when you get to exit, if you haven't registered your trademark, it's a huge flag that you haven't taken your IP seriously. So for God's sake, it's not expensive. Get on it.
And I will leverage. I will add on to that. That not only is it raising questions about what else you haven't protected, it's raising other questions in general. Okay, about your understanding of what's going on here, what you've done, and all the other things. So just to be clear, this is the problem with due diligence. Is that not the problem? It's just the way it works.
Right.
If you were doing due diligence on someone, you'd want it to be this way too. So trust me, they're doing it for their own protection. But the idea is to say, look, if you don't have these things done, not only is it going to ask question about everything that you know about what you're doing and how you're doing it, but it's going to make me big questions, harsher questions about whether or not this is something that I want to have. These are people that know what they're doing, and do I want them? Do I want to acquire this thing and integrate that company into mine, et cetera, right? So now it's not, is it always going to be a deal breaker? Not necessarily, right? But what Brent is trying to point out here is, obviously having this stuff, this is easy things. This is low hanging fruit.
It's low hanging fruit. The other thing is like, there's a big consumer education aspect to branding, right? So when you brand something, I mean, and this is a lawyer, so the branding experts out here be like, but anyway, right? So when you brand something, you're really just teaching the public or a portion of the public, like what this means,
what it means, right?
What to associate it with, right?
Mm-hmm.
And so and that takes, like, that's hard, right? Like getting the attention span of Joe Q public these days is challenging.
Totally.
And so it takes, a lot of times years and a lot of money and a lot of effort and consistency and delivery and all this and advertising and stuff like that to teach someone what the significance of your brand is. And so if you don't protect that, like that's a giant flush of assets, but also cash and effort that you're just letting go, right? It's a little criminal. And so absolutely register your name. Now, the other thing I want to talk about is sort of the nexus between innovation and trademarking, right? And naming. So when you come up with a novel good or service, you have to do that education thing, right? Like you have to teach the public that they want your thing. And so my example for this is gochujang sauce, which is one of humanity's highest achievements in the condiment category, right? It's a Korean chili sauce. It's like a little funky. It's kind of sweet. It's very tasty. It's on bibimbap, right?
Right.
And so a number of years ago, you could only buy gochujang sauce in Asian grocery stores, and if you could only figure out the Korean, right? And and then there's this company called Annie's, which is at least on the West Coast, and they decided to make kind of a mass market-ish gochujang sauce because they thought they could convince Americans to also put it on things like chicken skewers, which is also delicious, by the way. So they introduced gochujang sauce. Now Annie's can't trademark gochujang sauce, right? Because it's the generic word for this condiment. It's
like ketchup.
It's like ketchup, right? Like it's what we call the thing. Annie's can't trademark that word, right? But if Annie's releases that product and calls it gochujang sauce, like those of us who already know what it is will understand what it is, and the educational task will be lower, right? Yeah. So that's the tension when you release a new product. You can use generic or descriptive terms to make your educational task a little easier.
Right.
But then you're not going to be able to protect the terminology that you've just taught everybody to associate with that thing.
And what's the best example of that? Kleenex.
Yeah, well, I mean, so Kleenex was distinctive and it became
Sure.
generic.
They did it, but it was the other way around. So it became generic because right.
Yeah.
Gotcha.
Yeah,
I
at
see.
one
Right.
point, yeah,
Yeah. Makes
but
sense.
that's the idea, right? Like
Right.
that's when you're releasing a new thing, and you come up with like a descriptive-ish term because you feel like that's going to be an easier way to tell people about it,
Right.
then you're going to end up educating your consumer base to identify all of that learning to something you can protect. And so
Right.
what you should do, like what I tell people to do, right, is when you release a new product, like think of descriptive words and then think of like a product name that shouldn't be descriptive. It should have a little zhuzh to it,
Right.
right? And
Hmm.
use them both together and understand that the thing with a zhuzh is your trademark and the descriptive language is doing the educational heavy lifting for you.
Got it. Right. And there's no reason, by the way, where both things can appear together.
They should
Right.
appear together because you have some education to do.
That's it.
Yeah.
Right.
But
And
yeah.
so, right. So that's
So
why, again, so just to use our example, and I'm not saying it's the best one in the world or whatever, right? But I mean, the idea is that that's what we tried to do,
yeah.
right? Which is say,
Mm-hmm.
hey, look, we're going to talk about exiting, right? We're going to make it an active thing because that's what we're doing. We're actively planning this stuff and whatever. And what we're doing is giving you the way to drive this stuff forward. And so the engine aspect of it kind of came together, or whatever. Now, exit and engine alone, right? Can't
Yeah.
do that.
Yeah,
Put it
that's right.
together and lock it up in a way and whatever. Now it's a different thing. And it's, and we can talk about later. We'll talk about the tools that you can use to check this stuff
Mm-hmm.
and see and stuff like that too. But in any
Yeah.
case, that's the gist behind it. I'm not saying it's the best
Yeah.
thing in the world, but that's the idea, right?
So one thing I do, I come into this company that's about to exit, right? And they've invented products and they've taught people about the products and, but I can't, like, they don't have registrable trademarks because they've used generic and
Generic
descriptive
terms.
language,
Right.
and
Yeah.
that's a miss. So as you name your products, as you engage in this like consumer education journey, think about what's protectable,
Right.
you know?
Yep.
Because otherwise somebody's gonna like, now you walk into most grocery stores and there's gochujang sauce everywhere, right? Because
Sure.
now like, Annie's like, just educated Americans about putting on chicken skewers,
Right.
right? And it did it in a way that could not protect.
Correct. And therefore, and also, by the way, you are giving, again, in certain cases, it's fine to give stuff away or whatever. But that the idea is that, they spent a lot of money, Annie's,
Mm-hmm.
right, getting people to understand what it was. And what they ended up doing was helping a whole bunch of competitors do the same thing,
Yeah.
where the
Yeah.
competitors didn't have to spend the money.
Yeah, I mean, in order to get something in a grocery store, like you usually have to pay, like I think it's called a slotting allowance or something, right? But you got
Right.
to
Yeah.
pay the
Yeah.
store for shelf
Yeah.
space,
For shelf space.
right?
Right.
Because you're like, hey, store, we want you to sell your sauce, and the store's like, I don't know if you're going to move any of that sauce. I don't know what the hell that is. Pay a slot. So they paid for shelf space, right?
Right.
They launched advertising,
Yeah.
and great, they were successful, and now every competitor out there can reap the benefits of that
Potentially
success.
rose with that the tide of their boat, right? I mean, that's the
Yeah.
thing. Yeah, yeah.
Yeah.
And so, and again, copying, right? Anything's copyable. That's the first
Mm-hmm.
lesson. Okay, so know that anything that you do right out of the gate is copyable until you protect it.
Yep.
Right.
That's right.
And so
That's
what
right.
we're talking about right now, just to catch everybody up here, is again the different kinds of IP there are, and just disambiguating kind of what they are and how to use them and how to think about these things inside your own business. Okay, so the first one we talked about was what we're talking about is trademarks and copyright, right? And figuring out the lesson is you want generic terms so people understand what it is that you do, but you need to find some kind of, as you put it, zhuzh in the naming of those things so that you can then actually trademark, which gives you protection over those elements.
That's right. That's right. Yes. And then, like this is something trademark lawyers do, right?
Sure.
So the
Right.
ideal conversation for me is like, here's whoever's doing your branding, and I can sit here and figure out like how it looks from a trademark perspective, and we can arrive at a strategy that serves your education and sales goals and actually yields something at the end of the day that you can protect.
There you go. So
So
there's an actionable thing there. And also, by the way, there is, even in the naming, right, the name searches. And I think that one of the things that's always a big deal, especially around brand, right, is finding words and things like that you can own.
That's right.
Okay.
That's right.
That are going to give you things. So that's where making up words and using Latin and, look, exio. okay, is a, is a Greek term. I mean, it's
Yeah.
right. And we used it because it sounded, it sounded good.
Yeah.
And when we put it together, same thing. We can trademark it because we put it together with our word advisors and no one else can take that.
That's right.
Um,
That's
but
right. But you had to teach, but unlike exit, which we all understand, like you had to kind of teach us what exio means,
correct. And
which is
that's the
cool, right?
downside.
But then once you do it, you need to be able to own that.
That's it. And not have everybody else get to take advantage of the fact that we did that for everybody. And we're already
Yeah.
doing that already, right? We're already
Yep.
out there teaching everybody on behalf of everybody, of the entire industry. So
Mhm.
get it. But at the same time, there's a limit to, how, right now, right.
Yeah. Yeah.
It is a season of giving, but let's get,
Yeah. Keep what you can keep. Okay.
That's
So
it.
copyright.
Right.
Copyright. So copyright protects original works of authorship, a fixed and intangible a tangible medium of expression, right? So it was originally created, envisioned to be, to apply to, artworks and music and plays and performances and things like that. And then,
Right.
but it's got a lot, and all those things are important, right? Like, but it also has a broader, industrial or business sort of value. And so my best example of this is a company that this has been a number of years ago, right? But they prepared like professional certification applicants to take whatever tests were involved in that certification, right? And so, I mean, they're just kind of like, whether it's realtors or, beauticians or whatever, right?
Right.
But they had a lot of test questions that they had created over the years
Mm-hmm.
that they were using to teach and, and kind
Right.
of help people, get these certifications, right? And and they hadn't considered any of that to be copyrightable subject matter, so as they were preparing for an exit with like nothing but their trademark registration, and that was it, right? And they didn't have a lot of repeat customers, like people would kind of cycle through, they had their referral networks, right? But it didn't look like a business with the legs they needed.
Right.
So what we did was, like I they hired an intern and I taught her how to do copyright registrations, and she spent a summer creating a library of copyright registrations. And then when they get to exit, they're like, look, we have all these proprietary materials. And they said
Right.
proprietary and they meant it because it had been registered with the Copyright Office, and so that was that, that sort of recognized and formalized what was a really significant corporate asset in a way
Right.
that caused people to really think of this as something that was important and something that was really worth spending money on.
And let's point out right now that that adds value directly to the value of the company directly.
Yeah.
Okay.
Yeah.
So, I mean, yeah, that's a point and a multiple. Okay.
Mhm.
I just want to give
Yeah.
context, guys. Okay. So, I mean, you're talking about going from 5x to 6x because you have
Mhm.
potentially, because you have actually documented this stuff and have these things protected.
Yeah.
So it's no joke, right?
Yeah.
And what is the difference? What in real numbers? What's 5 to 6? That could be million. That could be $2 million,
Mhm.
right?
Yeah.
So just know that this is serious money. This is what we're talking about today. It's not a joke. And
Yeah.
being able to do it efficiently and have it done professionally by someone like Brenna is going to help you in spades, later on for sure.
Yeah, and we can figure out how to, again, like, with this company, it was the intern, and I made a
Mhm.
reform on the
Yeah,
copyright website, and it was easy peasy, right? So it
yeah,
doesn't need to be, but like, when you have, something, especially that you've spent a lot of time sort of creating, right? Like something that's, that you've had to invent, using
mhm,
words. If it's a tangible expression, you don't get right. You don't get exclusive rights to the underlying idea, just in the expression of that idea, but that can be
expression.
really powerful. Especially when, and the question comes up, right? Like, what is this business? Like, what is your competitive advantage? And the answer has to be like, these are the competitive advantages, and these are the exclusive rights that were attached to these competitive advantages.
Mhm.
This is
Yeah.
why there are barriers to everybody else's entry, and why you, buyer, can rest assured that you're going to make enough money on this deal to pay me what I want, and
And
come
what it's
away
and by the
happy.
way, and what it's worth, right? And the
Uh-huh.
idea is that this is what will happen, and I've seen it happen at least 5 times, okay? Which is that I didn't have stuff protected. The buyer recognizes that you don't have stuff protected, doesn't say it,
Yeah.
Okay. They don't say anything.
They don't say anything. Yeah.
They just take the company, and then they suddenly have this IP that you didn't know, whatever. They go patent
yeah.
it. They do that. They've got protection. They potentially have just raised the value of the company by
hmm
a large margin on day one.
Yeah. No, that's true. That's
Right.
absolutely true. Yeah.
So
Yeah.
that's the kind of stuff. It's just another thing. It's just like this is what we're saying and what we're trying to preach here is that there is work to do, and if you are smart about it and you're listening, you will be able to do these things that are going to add major money to the bottom line, and by the way, raise your saleability in general, because as you were pointing out, hey, look, the valuation of that of that training company or whatever, right, was like, that value was probably good. They probably had some process. They probably had some clients, and they probably had a big following. That's pretty good. Okay.
hmm
But the addition of that IP, okay, made that a real valuable company that no one else was going to be able to compete with. So if I
Yeah.
went to another training company and tried to buy them, right, I wouldn't see as much stuff as I saw with this one. And that makes, again, in a competitive situation that exiting sometimes is, this gives you real leverage.
And how we got there, right, was, I mean, company comes and says, we want to exit. I'm like, okay, well, what problems have you solved? Like, what is your competitive advantage? What's
Right.
the secret sauce? And the secret sauce was, like, people only have to take our course once and then they pass. And we offer it in, all these different disciplines, like all
It's
these different
because of the
certifications.
way that
But
you write the questions and the prep that you do that is now right, a copyrightable
yeah, our
situation.
training is our secret sauce.
Yeah.
Well, you show it to every applicant,
Right.
like it could walk right out the door.
Yeah.
If there's
Yeah.
no exclusive right attached to it, why the hell would somebody pay you for that? It took you
That's
20
right.
years to figure out, what the questions are and how regulators approach these things and like what teaches people,
Totally.
but
Yeah.
it walks, it's into, the thing about copyright, right, is the reason it exists is because anything that's a fixed and tangible medium is super easy to copy, you know? And
Of
so if
course.
you don't make it illegal, like there's no really reason for anybody to create anything. And
Right.
that was the thing with this company, right? Like if it's not illegal to copy you, why the hell wouldn't anybody? And why would I pay you for that?
That's right. And that's why, by the way, like is a good example just to be able to see this is to look at like some of like the knockoff like brand stuff that's out there, right? You walk down the
Mhm.
street in New York City or in Times Square, whatever, and you can buy, whatever, the Fendi bat, all that stuff,
Yep.
right? And you're just, or the
Mhm.
Rolex is another good example, right? About how the
Yeah.
Rolex the hand sweeps versus, but the idea, again, not to derail this, but just to show that the ability to protect these things, okay, even names and word and phrases and copper, and the way that you do it, your secret sauce becomes incredibly valuable to protect yourself now from competitors and people out there who might be wanting to try to take advantage of something, right?
Yeah.
And then the second horizon then of eventually exiting and having that be part of your value, right?
Yeah.
So
That's
those are
right.
the two things. So we talked about copyright, we talked about trademark. We got to talk about trade secrets.
Yes, let's talk about trade secrets. So trade secret is, any information that derives its value from being a secret that you have managed to keep a secret. And so if there's one kind of area of intellectual property that people don't know that they have until we kind of get in there and look at what they've got, it's trade secrets. And the question comes up, like, what is the subject matter that can be trade secret? It's pretty close to what can be patented. And so, one important question is, what should be a trade secret? What should be patented? Because like patents imply disclosure, you can't usually have both,
Right.
right? And that's a question that really depends on this situation. But my rule of thumb is if there's a question of degree, right? Like if we set the machine at 20 degrees and not 25 degrees because that yields a remarkably better whatever, like that's a
Right.
good trade secret because any kind of numerical range thing, it's hard to get a patent on it.
Right. Okay.
Yeah,
But that can be a trade secret, something
it
like
can be a
that.
trade secret. Yeah, you just have to not tell people. You've got to,
Right.
and so you've got to understand why it's valuable. You got to, and so what happens is companies are like, oh yeah, we've developed stuff, we have trade secrets. Like we can't really tell you what they are,
Right.
and then they don't, or they think about it when like, their shop owner like leaves and opens a competing business, and they're like, they want to sue him, and
Right.
then they sort of reverse engineer themselves into trade secrets, which is a bad idea. What you want to do is be proactive about your trade secrets, right? Like be asking yourselves, what problems am I solving, right? How to make the fiber is longer, or the, cheese caramelized, or like food processing is a really rich area for trade secrets, right?
Right. Right.
But anything like that, right? So when you solve a technical problem, you should note it, like write it down, keep it somewhere locked away, password protected, make sure that your employees who have access to this information are under NDA, make sure that those employees have assigned their intellectual property, their creations to you, their employer, which, is sometimes necessary and sometimes not, but something you should always do just in case.
And by the way,
And
that can
then,
happen through employment contract, FYI, right?
yeah,
Just as a
yeah,
thing. So it's not like you have to have a separate agreement somewhere or
you
whatever.
don't. It
Yeah.
should be part of the employment contract, and yeah. And so you should. But my point is, like, you should keep track of your trade secrets. Like when you invent something, you should be like, oh, this is an invention, and this is why it's helpful. This is a trade secret. And then when you go into diligence, you can be like, our processes are proprietary. They are trade secreted. These are they're trade secrets. Like these are the things that we do to protect their secrecy.
Mm-hmm.
And this is intellectual property. And so unlike a patent process, which is expensive and kind of arduous sometimes, like to have a trade secret, all you have to do is recognize it and keep it secret.
That's really this is let's just stop right here, because I think this involves some serious bolding and underlining. Okay.
Yeah, it does.
Yeah, right. I mean, this is the kind of stuff, guys. This is why this right now, this is the cost, this is the price of admission right now. Okay.
Yep.
Which is very low, but still the idea here, okay, Brenna, is this, that anything that you do to slightly modify, to make it your special way of doing it, whatever, we cook bricks and we only cook them for exactly 12 and a half minutes, right? Other people cook their bricks 14 minutes.
Yep.
Right. The idea, taking that, write it down, keep it secret, meaning that you're protecting it, you're putting it away, you're taking action steps that are demonstrable.
Password, protect it, keep it on server. So,
that's it.
Yeah. That's it. That's it. Right. And so, I mean, there are, especially when you're manufacturing something, like there are 1,001 things that you do to make the margins work. Right. Like if the brick can cook in 15 minutes and not, 20, like that's 5 minutes of energy expenditure and time and stuff like that. Right. Those are the sorts of things that make things profitable. Right. And there are also the sort of things that, like you're often kind of low level employees can like walk right out the door with, if you haven't designated them and taken care of them as trade secrets. Like, so make sure that your employees understand what's proprietary information and the fact that they can't disclose it to anyone else. They can't walk out the door with it. Right. And so then when you come to exit and you're like, we have a proprietary process that means that we can be profitable and you can't, and it's in the sealed part of the data room and all that stuff. And you get the question, well, what makes this a trade secret? You'd be like, well, we've protected it since we came up with it. The employees understand they can't take it. Like it's a trade secret. And then you have a proprietary process. You have intellectual property that you're then selling, that will tell your buyer that you can be successful, whereas competitors can't, and you have to pay me for this.
Right. What in the case of again, this trade secret is such a big deal because I think this is where lots of people will find kind of hidden IP, right? And knowing that where your trade secrets, how much damage does it do in due diligence? And so the point is that, let's say that you come into due diligence and the question comes up, right? Do you have any trade secrets or things like that or whatever that you're using? And you go, I guess, whatever. And then during that call, you realize, oh, maybe we do, but I didn't do anything about that.
Yeah. I mean, you may be lucky, right? Like, as a bare fact of the matter, none of your employees have left and you haven't advertised as trade secrets. You still got a credible trade secret. On the other hand, it may have been like listed as your secret sauce on your website for the last 10 years, in which case no one can help you, or you may have a lot of turnover and there may be a lot of people wandering out there who know this, right? And in which case it has left the barn probably at that point.
Got it. And so from a value standpoint, okay, obviously as I go through this, you're in a situation where you're kind of like, well, yeah, that ship may have sailed already. And who knows who's taken that and whatever. So therefore we can't ever think that it could be a trade secret because you hadn't taken the steps to demonstrably protect it.
Yeah.
Fair enough. So that's the idea. So the answer to the question is, do it early, do it often, do it now, well in advance of getting to a place where you're thinking about selling the company.
Yeah. And if you haven't, like if this is, if you've been operating for a while and you're just watching this and going, oh, there's still, it depends is the answer, right? Like there still could be a lot there.
Right.
It's just a process of kind of going into it and figuring
Right.
out, and so don't go
But
listing invalid trade secrets as corporate assets. It will
if you
discredit you.
say,
But
and here's the example, if you say on your website, we cooked the bricks to 12 and 12, whatever, 12 degrees, 12 and a half degrees, exactly whatever. And you say that that's what makes you different. That is no longer a trade secret.
it's no longer a trade secret.
Right.
Yeah.
So just know
Yeah.
that's the difference. And that's why you have copyright to protect your secret sauce. And you've got, right now you've got the on this side of things, you're talking about the trade secrets thing. You're talking about things that you don't tell people and that you want to keep protected and hidden away so that, again, people can't make the same brick that you make.
Yeah. Yeah.
Right.
And then the last category just quickly is patents. Like people know whether they have patents or not. So it's not some hidden form of IP that I discover when I get in there usually, or if I do, like, wow, that's a sign. Like there's a lot of art in figuring out what to patent, what not to patent, how to do it. It takes years to get a patent and it's expensive. So this is not something you can start 6 months out of your exit. It is something you should think about. A lot of things are patentable that people don't really realize are patentable, but that's
Right.
a bigger discussion.
Yep.
Yeah, for the I don't know if I have IP or not crowd, like you just pay the big places to really move the needle are usually trademark, sometimes copyright, and almost always trade secret.
Right. And that's really good because the patent thing is harder. The patent thing does, as we talked about, we opened up. I mean, in the history of this thing, the patent really is that protection of an idea that no one else has had before. And that's really the big thing. Right. And so you got to pass that test. How you do it. There are certain circumstances where how you do it makes it different and makes it new. And so therefore that's patentable, but it is a process, right? And it is something that can take a long time. It can cost a lot of money. And the answer is you better be sure that you've got something before you really do this. Right. I mean,
and talk to a lawyer, right? Like talk to
sure,
somebody who's going to talk it through with it. Like this is a hard decision for you to make on your own.
That's it.
But
you do have these other things. And I think the most important thing to know, to walk away with today, is that the patent is like, that's the obvious thing.
Yeah.
But there's these 3 other areas, right, of IP that basically are potentially going to add value to your stuff right away if you can actually harness it. And in the case of the copyright and the trademark, there's obviously some legal things that you can do that way, but there are websites and places like that potentially could help you do that. Obviously, any kind of IP attorney and that kind of thing is going to help you do those things. And then of course the trade secrets thing, which I think is just, the trade secret thing to me, and this is what blew me away, when I even learned this, because I had no clue. And I go back to my own exit, 15 years ago or whatever. And I'm like, oh my God, all the things we had.
Yeah.
Oh my God, all the things we had that just walked out the door that we never thought about. We never thought that was something. And so the lesson here, guys, today, if you take away one thing from this, okay, it's that you probably do actually have IP, especially in the form of trade secrets, right? That you can actually take advantage of now, that doing so will immediately raise the value and saleability of your company.
That's right. That's right. And the biggest mistake I see people make is not thinking about it at all,
right,
or in time.
And by the way, we talk about this with everything that we do, right? It's all about time, because you start this, most people start this process way too late.
Yeah.
They don't know what to look for. They don't understand what's going to happen. And then they get into it and they're sitting there going, do we have any IP? Because they're asking if we have any IP. And you're going, I don't know, what's IP? And then suddenly you're like, right. You're in this unraveling of the deal.
Yeah. Yep. So now it's early often.
So Brenna, we've got a couple of questions. Can I bring some things up for you? Okay.
Yes, please.
So the first thing is that, how do I know what IP I actually have? Okay. And we've never really formally documented anything. So the question is, what's the one thing you could do right now that would give people at least a kind of an insight into what they even have?
Get a catalog of problems that you have solved. Figure out what problems that you have had to solve and how you've solved them.
Excellent.
Yep.
That's good.
And then we work from there.
And that's going to give you some potential things that might actually be patentable. It will give you some things that will definitely be intellectual. It will definitely be trade secret, right? And then of course you're going to come across your copyrights, And again, look at your logos, look at your,
Yeah.
right. Look at
Yeah.
the, the protecting the things, the assets and the whole thing that you've been out there using for,
Mm-hmm.
I can't believe the number of logos that I look
Yeah.
at and don't see any kind of copyright, trademark, or
And
registration,
trademark. Yeah.
right?
Yeah.
But then I think
Yeah.
back to some of the big clients that I've worked for. I think of someone like Coldwell Banker, who had so much IP and every single little lockup and no and whatever,
Um,
because they had this is actually a
mm,
good example, because they had a big problem that you pointed out, which was that their name, to the day at which I stopped working for them back probably in 2009. Okay. But what I can tell you is that from day one, one of the biggest challenges they had in marketing was people thinking they were a bank,
right. Right. Yeah, that's the education. Like that's,
right?
you can question the trademark selection
Well,
there,
they
but
had it
also
all
that's the
locked up. They
education
had
piece.
the registration stuff, whatever. But the
Yeah.
problem was they still had a pretty significant
Yeah.
education issue in terms of letting people know what it was they
Yeah.
did, and that haunted them and followed them around forever, right?
Yeah.
So it's even these big companies, face these challenges. Just so you know, you're not alone.
Yeah.
Um,
No, it is like one fun example is T-Mobile, the uncarrier. Like they
right,
didn't like that didn't come out of a branding think tank, right? Like they just
right,
woke up one day and discovered that's how their employees were referring to them. And
right.
so, like hidden trademarks is a thing,
Yeah,
like that's
right,
something else that we look at is, how do you talk about what you do? How do you educate people about what you do?
right,
How
right,
can we
right.
figure out what's
Because
trademarkable and
all
what's
those things
important?
potentially there's trademark stuff, or at least intellectual property inside all that stuff.
Yeah.
Um,
Yeah.
so let's say we developed several internal processes that give us an advantage. That's good.
Nice.
How do we decide whether to patent them or to keep them as trade secrets?
And again, if they're kind of incremental, then they're probably trade secrets,
Okay, got it.
But this is where it really helps talk to a lawyer about
Right.
it. It's worth paying for a little time to kind of, figure that out.
Yeah.
I will say you lose the right to patent stuff a year after you commercialize it, and then it's gone, gone, gone. So you can't commercialize something forever and then kind of kick that decision down the road. You have to decide kind of early in the process.
Right. Right.
Um, yeah.
Here's one that I just thought of, actually, because I think this is important to know too. Jurisdiction, because
Yeah.
right, there are every country,
Uh-huh.
potentially every entity, other
Intellectual
entities
property
that
rights are
exist.
national. Yep, and so yeah, you have to have rights in every jurisdiction that you want to assert. There are
Mhm.
treaties that make this a little easier,
Okay.
but it's still something, it's not easy. It's still something that you've got to really think about, and it can be quite expensive. So thinking about that in terms of, like
Right.
again, this is another place where you need some help. There's no
Right.
one size fits all
What
advice I can give you.
if I have a business in the United States, okay, and I do most of my business in the United States, okay.
Mhm.
How and I let's say that I have a trademark on the name, okay. Um, how am I protected in other countries?
I mean, you're kinda not,
Right.
right? Like, you're really just not. And
Mhm.
and so there's so international copyright registration or copyright protection is pretty easy. Trademark protection is not quite as easy, but it's very doable.
Okay.
And it's important to get international trademark registrations because other people can kinda scoop you at their registration offices. Like, that's the thing you gotta really think about.
Right.
International patent protection is hard. It's also doable. It's just hard.
Got it.
Um, yeah,
Okay.
yeah, but definitely think
But
about your trademarks.
yeah, and look, this is I think this has been incredibly valuable. I mean, the reality here, Brenna, is to say that look, bottom line is there are more than one way to skin this IP cat. Okay. The idea is
Mhm,
that you got to look inside and examine yourself. This is what we ask you to do all the time at Exit Engine. Okay. Is examining yourself, examine the business, look under the waterline, as we say. Okay. And be able to see inside and what is the IP that I have. All right.
yeah,
Do I have patents? Do I have copyright? Do I have trademark? Do I have trade secrets? And trade secrets is the one that most people miss and aren't
mhm,
thinking about. And they are the quickest way potentially to be, well, the trademark and the copyright of your logo and those defensible things like that are going to be important. But this ability to be able to look at trade secrets as the way that you do stuff, and understanding that the way that you make them a trade secret is by not talking about them.
yeah,
right?
Yeah.
And that's
Hmm.
really the big thing, because
Yeah.
we're so excited to run out there and go, oh, look, we did this thing so special, and this is what we do it, and boom, and you're dead in the water, right? You've just
Yeah.
given away the whole enchilada. And so you got to be careful about how you do this. But the bottom line is, when you're in this process early on, well before you're thinking about exiting, okay? And look, if you are thinking about exiting now, it's not too late, okay? But what you want to do is you want to talk to Brenna or someone like Brenna, okay?
Hmm.
And you can reach Brenna. Brenna is all over the Exit Engine ecosystem. She's one of our favorite advisory partners, because she is so good at this stuff, and she's so active and wants to help. And she's so passionate about this whole thing, and she really sees how it adds the value and salability of the company, right? So, Brenna, how can people reach you directly if they want to actually and talk about it in Invenio as a resource?
Yeah. So this is where a slide would help. But yeah, so the long form website is inveniolaw.com.
Mhm.
And my email address is bkl@inveniolaw.com. You can
Yep,
also find me on LinkedIn, and you can reach out that way. Yeah, and I'm
that's great.
happy to
Excellent.
talk about what you got going, and what you could do with it.
Very cool, guys. There are so many things around IP. This is really just the tip of the iceberg, so to speak, right? I mean, so many things to investigate. Look, I hope you found this, interesting and insightful. I know I did. I think, again, looking at these 4 different types of IP and examining your businesses for what you might have, there's an exercise that you can do right now. Right,
Mhm.
right now, you can get in there, you can look at it, and then you can call someone like Brenna and say, Brenna, here's what I got. Help me
Mhm.
strategically figure out how to put this together, and let me do this in a time frame well before I'm ready to exit, right?
Yeah.
As always, we say. Brennan, thank you so much. Excuse me. Ooh, thank you so much for doing this. Really appreciate your time today. I think this is really, really interesting, guys. This will we'll actually have this up so that if anybody didn't see it live, we'll actually have it up there on our YouTube channel within a few hours, so you guys can check this stuff out. Brendan Lagarde from Invenio Law, thank you so much again for doing this today. Really appreciate it,
Thank you for
guys.
having me.
At a pleasure. We'll do it again. At Exit Engine, guys, right? These are the kinds of people that you get to learn and know at Exit Engine. Okay, people like Brenna, who are bringing this kind of insight, who really understand how it is a business like yours can actually compete in this day and age, and can do some of the things that these large companies are doing to help improve their value and salability. They're not difficult. You just have to know they exist, right?
Yeah.
And that's what we're trying to do at Exit Engine, is teach you those things, get you the learning that you need, hook you up with the advisory partners you need to actually get these things done, and create an engineer a valuable exit on your own terms. Go to myexitengine.com right now to get started to do on yours. And Brenna, thank you so much for doing this. Really appreciate it. And we'll do another one very soon. Have a great day, guys. The rest of your day. Thank you so much.